My name is Navarubni.Afghanistan. My ID number is DEM0220011. Today, me and my group members going to prison about Dato Sri Anwar bin Ibrahim versus Public Prosecutor case. The topic of the case we selected as sentencing. My learned Chief Justice will deal with the appeal against the sentence. Muhammad Desaidin, Chief Justice. On sentence, the trial judge passed a sentence of 6 years imprisonment for each of the 4 charges of run concurrently from the date of conviction. Then, the learned judge based on his decision on the following factors. First is, he considered the general principles of sentencing which the court should take into account, namely the gravity of the offence, circumstance surrounding the commission of the offence, the antecedents of the appellant, any factor that warrants special attention in favor or against the appellant and public interest. Secondly, in assessing the appropriate sentence, he considered the object of emergency, essential powers, audience, No. 22 of 1970. Any sentence for 2(1) of the ordinance must take into account the position occupied by the politician or public officer concerned and the nature of the abuse. He relied on Nunes VPP 1982 to MLJ 114. Therefore, bearing in mind the position and status of the appellant and the manner in which the abuse is positioned as the second most powerful officer of the executive, it was therefore appropriate for him to impose a custodial sentence. That's all from me. Next 6 will continue by my group members. Thank you.
Hi guys, my name is Yashina Sukmar from batch 20. My ID number is 0320007. Thirdly, with regard to the appropriate custodial sentence, the learned judge was of the view that as the maximum term of imprisonment under Section 201 is 14 years, the initial calculation of the sentence to be imposed would be in the range of 9 years. However, from the initial figure calculated, allowance was made for the appellant's service to the nation for 16 years and his previous clean record. Against these factors, he held that the offences which the appellant committed were not technical or inadvertent, but ones that were premeditated and executed over a period of time. He also found that the appellant did not display any sign of remorse toward further trial. Fourthly, he considered whenever the sentence should take effect from the date of remand. In the exercise of his discretion, he declined to backdate the sentence of 6 years imprisonment to commence from the date of arrest. His reasons are as follows at p. 233. In the case of the accused, it must be observed that he has been in remand in respect of 10 charges, 5 of which related to sodomy allegedly committed by him. His remand is also in respect of offences other than the 4 charges for which I had found him guilty. In R.V. M.C. Hart 1985 1 and as WLR 588. It was held that is desirable to backdate a sentence where a pretrial custody exclusively refers to the offence for which sentence is behind passed. See also RV Read 1992 to VR 484 as the accused remand is also in respect of other offences. The commencement of the sentence from his date of arrest will therefore be not appropriate. Thank you.
Hi, my name is Kausalya, daughter of Chandran. Thus, I took into the account the period spent by the accused in remand, even in the absence of any application having been made to the effect by reducing the length of sentences that will otherwise have been imposed. In the circumstance, I convicted the accused and passed a sentence of 6 years imprisonment in respect of each of the 4 charges. In the Court of Appeal, Mr. Cristiano Fernandez had submitted that the sentences handed down by the trial judge was excessive and referred to PPB Dato Haji Muhammad Muslim bin Haji Othman, Haji Abdul Ghali bin Ishaq, and Anwar VPP in support of his plea in mitigation. The Court of Appeal, however, summarily rejected counsel's submission and entirely agreed with the judgment of the trial judge on sentences. The crucial issue before us here is whether or not the imposition of 6 years imprisonment for each of the 4 charges to run currently from the date of conviction is manifestly excessive. Thank you.
The learned judge gave his reason, which we have adverted to above, in imposing a custodial sentence of 6 years from the date of conviction. He also gave his reason for not backdating the sentence from the date of arrest. Clearly, the learned judge was exercising his discretionary power under Section 282D of the Criminal Procedure Code. The section reads as follows. With regard to sentence of imprisonment, the following provision shall be followed. Every sentence of imprisonment shall take effect from the date of on which it was passed, unless for the court passing the sentence is the sentence harsh and manifestly excessive. We should paraphrase in this way, as this is an appeal against the exercise by the learned judge of a discretion vested in him. Is the sentence so far outside the normal discretion limits as to enable this court to say that is imposition must have involved an error of law?
Hi Miss, my name is Kodisan Son of Sarah and my ID number is DEM03200033. Today I just want to presentation about the case study of Anwar case. Today I just want to talk about is human nature being what is different judges applying the same principle of at the same time in the same country to similar facts may sometimes reach different conclusion. See Jameson v. Jameson. It is for that reason that some very conspicuous judges have thought it their duty to visit particular crimes with exemplary sentence, while others equally constitutes have thought it their duty to view the same crimes with leniency. The second one is therefore sentences do vary in apparently similar circumstance with the habit of mind of the particular judge. It is for that reason also that this court has said it again and again. It will not normally interfere with sentence and the possibility or even the probability that another court would have imposed a different sentences is not sufficient per se to warrant this court's interference. The third one is we are in full agreement with the statement of principle enunciated above. The fourth one is, after considering the reason given by the learned judge, we are satisfied that the imposition of the sentences of 6 years imprisonment to commons from the date of conviction has not occasioned an error of principle or law. Therefore, we see no reason to interfere with the exercise of discretion vested in him. Accordingly, we dismiss the appeal against sentence. Thank you, Miss.